It's a home seller's worst nightmare. You just closed on the sale of your home, and all of a sudden you find yourself sued by the buyer because of something that they said you didn't disclose. That's exactly what happened in the case of Hahn versus McElroy. Let me first tell you the facts of the case, then I'll tell you what was decided by the judge, and then finally I'll give you some ideas about how I would have handled this to avoid being in court in the first place. So back in 2018, Mr. Hahn purchased this property, this lovely single-story ranch with a crawl space from the McElroys. It's in Yorkville, Kendall County, Illinois. The McElroys had owned and lived in the place for 17 years, and during that time they had various issues with water in the crawl space. Finally, in 2015, the sump pump failed and they had a flood in the crawl space. At that time, they had everything repaired, sorted out, and between then and the sale in 2018, they had not been in the crawl space at all. Now, shortly after Mr. Hahn purchased the property in 2018, he noticed a musty, dank smell in one of the bedrooms. And upon further investigation into the crawl space, he saw that there was dampness and what appeared to be mold. He called in a remediation company who attributed this condition to a crack in the foundation and the dryer vent being vented into the crawl space rather than out of the home. Feeling that this was something the McElroys must have known about and failed to disclose, Mr. Hahn filed a lawsuit. He alleged in the lawsuit that the McElroys were required to disclose this condition to him during the transaction, and failing to disclose was a violation of any number of either intentional or negligent misrepresentations. Now, interestingly enough, the case was divided by directed verdict in favor of the McElroys. And what that means essentially is that the judge in the case determined that after Mr. Hahn put on all of his evidence, he didn't state enough facts to support a claim for any of the things he was alleging that the McElroys either did or didn't do. Not a great place to be if you are the plaintiff's trial attorney there. And essentially it all boiled down to the failure to develop any factual basis for the idea that the McElroys knew about this and therefore could disclose it. Essentially, if you don't know about something, how are you to disclose it? Now, although this was a success for the seller defendant in this instance, I would say that the fact that they even ended up in court suggests a failure of strategic planning during the course of the transaction pre-closing. If I were to recommend one thing for someone in a similar situation, it would be to be a little bit more open about what happened in the past. Anytime you're able to disclose something that happened but that was repaired and you haven't had any issues with subsequently, it's usually a win for you as a seller. You leave a lot less space for a buyer to come back afterward and say, well, you didn't tell me about that. Instead, you're free to say, look, we told you everything we knew. Sometimes things pop up soon after closing, and that's often where these kinds of things get really messy. When something happens, whether or not the seller could, should, might have been able to disclose it, if it happens right after closing, often the buyer wants someone to blame and the seller is that person. Interestingly enough, at the end of the case, the trial judge did award the McElroys over $27,000 in attorney's fees based on the fee shifting provision in the real estate contract. So as a seller, if you do get sued frivolously in such a situation, you do have a remedy. Although that is kind of a plan B in terms of how to deal with a situation where a buyer wants to file a lawsuit against you, at least there is something that you can do if that happens. Now, as a buyer, be careful. The thing that I often say to buyers that come back to me and they say, well, your seller didn't disclose something is, well, it's the old caveat emptor, buyer beware. To wrap things up, if you have an example of something like this to happen to you, let me know in the comments. I'd love to hear about it. If you've got questions about these kinds of things, DM me, ask me in the comments, get a conversation going. It's another instance of a situation where a good strategy is going to help avoid a bad situation later on. And my firm is just the kind of firm that loves a good strategy.